I'm Clay Avery, your host for the night. Tonight's webcast qualifies for that 1 hour of state-required ESD Commissioner Training. The webinar is certified and sponsored, as always, by our friends at the V.G. Young Institute for County Government, part of the Texas A&M AgriLife Extension Service. At the end of the program, you'll be given instructions on how to apply for your 1 hour of credit. Again, so you have to stay with us all the way through and be sure and get those instructions on how to apply for credit. Tonight's webcast, as usual, will give you the opportunity to ask questions. I want to let you know how to do that right away. You can call us at 512-251-8101. Operators, as they say, are standing by. You can email us at safed@texas.net. That's SAFED, all one word, at Texas, spelled out, .net. Text me right here in the studio, 512-567-0857. Normal text messaging rates may apply there, and please do not call that number as I cannot answer you live while I'm hosting the webcast. You can even fax your questions into us here at 512-251-8152 if you choose to go that route. Now, let's get on with our presentation. If you've been to the safety conference in the last 5 years or so, you'll recognize Zindia Thomas. She is a familiar face to frequent safety conference goers. She's presented at numerous conferences as the Assistant Attorney General. She's now a new face, or an old face in a new place. She's joined the Texas Municipal League and is Assistant General Counsel, providing legal assistance to municipalities and other local jurisdictions like ESDs. As an Assistant AG, she worked in various divisions, including the Administrative Law Division, assisting state agencies with various issues. Previously, she worked in the White-Collar Crime and Public Integrity section of the Criminal Prosecution Division. It's a lot of words. Before joining the OAG in June of 2001, Ms. Thomas was a legislative aide for the State Representative Robert Janelle during the 77th Texas Legislature, and was an Assistant City Attorney for the City of Austin in the Austin Municipal Court. She holds a Bachelor of Arts in History and Government from the University of Texas at Austin and a Juris Doctor from California Western School of Law. She's here to present on ethics. It's good to see your familiar face, and please take it away.
Hi, Clay. How are you?
I'm great. I'm doing well.
Yes, we're going to do ethics, what I like to call traps for the unwary. I kind of stole that from the AG's office, but that's okay. Today we're going to go through a lot of different topics, and you can see that it's going to be conflicts of interest, because there's two main conflicts of interest. There's going to be disclosure of interested parties, which is a new law that has come out, gifts to public servants, and there are exceptions to that, honorariums, misuse of government property, misuse of official information, nepotism, dual office holding, incompatibility, and bribery. Hopefully we will get through all that in the hour or so that we have today. So why don't we just get started? We're going to start with conflicts of interest. I like to call part 1, which is Local Government Code, Chapter 171. And basically, what is that conflict of interest? Well, basically, it prohibits local public officials from discussing, deciding, or voting on issues that the local public official has a substantial interest in, either a business entity or a real property. And who is considered a local public official? Well, that is defined, either it's an elected or an appointed official. It doesn't matter if you're paid or unpaid. As long as you exercise responsibility that are more than advisory in nature, you're going to fall under this statute. There are two types of conflict of interest under this: substantial interest in business entity or a substantial interest in real property. The business entity one basically is when the local public official has a substantial financial interest in a business entity that has an issue before his governmental unit. And of course, substantial interest in real property has to do with a substantial financial interest in a real property that might be affected by actions of his local government. So we're going to go into substantial interest of business entity, and how you determine whether or not you're going to be affected by this as a local government entity or a local government officer is basically you have to look at either your stock interest, your other ownership interest, income interest, or close family members with any of the above. So if you have a stock interest, that basically means you own 10% or more of the total voting stock or share in that business entity, which is considered to be either sole propriety, partnership, firm, or corporation as defined below. Other ownership interest is either you own either 10% or more, or you have 15,000 or more of fair market value in that business entity, or you're an income interest. That means you're getting at least 10% of your gross income from the previous year from that business entity. And then if you have a close family member, either in the first degree of consanguinity, which is blood, and it did take me a long time to learn how to say that word.
Consanguinity.
Yes, or affinity, which is marriage, then that is also going to affect you. So the test is a two-part test: substantial interest analysis, which is basically what we just went through. Do you have a substantial interest in a business entity? And then whether or not you have a special economic effect. And that is basically determined whether the actions that local governmental body is going to consider would have a special economic effect on your business entity, distinguishable from the general effect on the public. So basically, if they make a decision and it's really only going to affect you and not the public in general, you are probably going to have a conflict of interest issue. We're going to switch to the real property. So to determine you have a substantial interest in real property, you either have to have $2,500 ownership of interest, that's legal or equitable interest in real property, or you have a close relative, basically in the first degree of consanguinity or affinity with the same type of ownership interest. And then the test is similar to business entities, real property. You do that first test to determine whether or not you have a substantial interest in real property, and then you need to figure out the special economic effect on you, which is the local governmental body is considering that would have a special effect on you as opposed to the public. So if it's going to affect your particular piece of property more or especially than it will generally affect the public, then you're also going to have a conflict of interest. And then what you have to do if you figure out you have a conflict of interest under 171, you have to file an affidavit that states the nature of that conflict and give it to the record keeper of your governmental body. Abstain from discussion or any other proceeding, and abstain from voting. So there's no voting, there's no discussion, and you have to fill out an affidavit. And then the consequences for not doing any of those is there's civil consequences. So any action taken by the governmental body is going to be voidable. And then there's 4 situations in which you can have criminal liability, which will be a Class A misdemeanor that's punishable by a fine of not to exceed $4,000 and or up to 1 year in jail. So if you fail to file that affidavit, if you participate in discussion on that item or vote on that item, if you're serving as a surety for any business entity that has work, business, or contract of any amount with the governmental body, or a surety of any official bond that requires for an official of a governmental body of the local entity, you're looking at a criminal offense. That's a lot to pay for just going off and filling the affidavit and not doing any of the discussion or the voting. And then, of course, you could possibly be removed from office. So that's basically conflicts of interest, Chapter 171. That's Part 1. We're going to move on to Part 2, which is Chapter 176 of the Local Government Code. And what is conflict of interest under Chapter 176? Well, it requires a vendor or a local government officer of a local governmental entity to disclose certain business relationships. And there's a lot of definitions to this. They added definitions this last legislative session. This first one, which defines what a local governmental entity, you can figure out. It's a county, a city, school district. They added water districts last legislative session, for it. So that's your government entity. It does include associations, corporations, organizations of governmental entities organized. So basically it's your general county, city, school districts, stuff like that. What is a local governmental officer? Well, that's a member of the governmental body of that local governmental entity. It's the executive director, the superintendent, the administrator of the local governmental entity, or as they changed this last legislative session, an agent of the local governmental entity, the governmental entity who exercises discretion in the planning, recommending, selecting, or contracting of a vendor. So that used to say employee, but now it's an agent. That could include an employee. It just depends on how it turns out. Vendor, they added this definition, and so it is a person who enters or seeks to enter into a contract with the local governmental entity. The term includes an agent of the vendor. It also includes officer or employees of a state agency. That individual is acting in a private capacity to enter into that contract. It doesn't include a state agency except for the Texas correctional industry, and I'm sure y'all can guess what they do. And then, of course, there's a definition of agent. So it's a third party who undertakes to transact some business or manage some affairs for another person by the authority or on the account of another one. And the change is that they do include an employee. So now agents do include employees. Family members, persons related to another person within the first degree of consanguinity or affinity. And family relationship, which is added, was a relationship between a person and another person within the third degree of consanguinity or the second degree of affinity. We will talk about all that when we get to nepotism, I promise. And then there's a definition of gift. And so it's a benefit offered by a person, including food, lodging, transportation, and entertainment, accepted as a guest. The term does not include a benefit offered on the account of kinship or personal, professional, or business relationship independent of the official status of the recipient. So you can still get gifts from your husband, your wife, your parents, your kids, or your business partner for this definition. So who are the conflict of disclosure statements and the conflict of interest questionnaires to be filed with? Well, those statements and questionnaires are supposed to be filed with the record administrator of your local governmental entity. That person is the director, the county clerk, the city secretary. It's basically who the local government entity has designated to maintain those statements and questionnaires. And if the local government entity maintains a website, then they have to put those statements and questionnaires on their website. When is the local governmental officer required to file the conflict disclosure statement? Well, it's a two-part test. The officer is required when, part one, a vendor enters into a contract with the local governmental entity, or the local government entity is considering entering into a contract with the vendor, and part two, the vendor has an employment or other business relationship with the local governmental officer or a family member of the officer that results in either the officer or the family member receiving taxable income that exceeds $2,500 during the 12 months period preceding the date that it becomes aware that the contract between the local government entity and the vendor has been executed, or that they're considering entering into the contract. What the hell did I just say? Basically, if the vendor has a business relationship with either the governmental officer or a family member of that governmental officer, based off all those definitions we went through before, and they're receiving a taxable income of at least $2,500 within the preceding 12 months of either they entered into the contract or they're considering entering a contract, that is going to be, you're going to have to fill out that questionnaire. Or the other part to part two is the vendor has given to the local governmental officer or their family member aggregate value of more than $100, a gift basically of more than $100 in the 12-month period preceding the date when the officer is aware that they're signing a contract with that vendor, or basically they're about to enter into a contract with that vendor, or as they add it, has a family relationship with the local government officer. So you have to really look at the test. There's a lot of parts to it, but in general, basically, if the vendor has a relationship with the local government officer or the family member, and either they're getting taxable income or $2,500 or more, or they're getting a gift of more than $100 in the 12-month period preceding a contract or entering into a contract, they're going to have to fill out this questionnaire. When is it supposed to be filed? Well, no later than 5 p.m. on the 7th business day that the officer becomes aware of the facts that they're required to file this statement. So if you go through that whole analysis we just went through and you figure out you should file it, you need to file it by the 7th day by 5 p.m. What are the consequences of not filing it? Well, the officer commits an offense if they're required to file it and knowingly doesn't file it. There is an exception, is when the governmental entity tells you about it and then you cure it within 7 days, then you're not going to run afoul of this. But you could get reprimand or suspended or terminated employment if an employee who knowingly fails to comply. So make sure you do this form. We're going to switch to the vendors now. And the vendors also have a form they have to fill out. They call that the conflict of interest questionnaire. I don't know who thought of these names for these forms, but anyway. So a vendor is required to fill out this form when it has a business relationship with a local governmental entity and it has an employment or business relationship with the local government officer or a officer's family members, like we said before, when they receive a taxable income of more than $2,500 in the preceding 12 months, or they have given a gift to the local officer or his family member of more than $100 in the preceding 12 months, or has a family relationship with the local government officer of that local governmental entity. So it's still kind of the same analysis as before with the local governmental officer, same with the vendor. So they also have to file their conflict of interest questionnaire no later than the 7th business day, after which the later they follow the date the vendor begins discussions or negotiations to enter into a contract, or they submit an application or response to a request for a proposal or a bid or another writing related to the potential contract, or the date they become aware of an employment or other business relationship with the local government officer or the family member, or they gave a gift to that officer or family member, or they have the family relationship with the local governmental officer. And then, of course, their consequences becomes an offense when they are required to file the questionnaire and either knowingly fail to file it, and when they become aware that they should, or they knowingly fail to update the questionnaire when they become aware of an event that makes a statement in the questionnaire previously filed incomplete or inaccurate. And they also have the exception once they've been told to be aware they have 7 business days to basically cure, and they've given the governmental body the discretion to declare that contract void if they determine that the vendor failed to file a questionnaire. So that is Local Government Code Chapter 176. What are the possible offenses for failing to file either the statement or the questionnaire? You're looking at a Class C misdemeanor if the contract is less than $1 million. So basically that's a fine only, like I say, a slap on the wrist. Class B misdemeanor if the contract is at least $1 million but less than $5 million. You're looking at fines and jail time. It's Class A misdemeanor, and we know it's about $4,000 fine in a year in jail. If the amount is, it should be more than $5 million.
More than $5 million.
More than $5 million, yes.
It's a Class A misdemeanor.
Yes.
Okay.
So, and that would be Chapter 176. We're going to move on to disclosure of interested parties. Government Code 2252.908. This was just added the last legislative session. It's become a huge issue over the last year or so about what it actually does. So basically what it is a business entity that is going to enter into a contract with a governmental entity or a state agency must disclose interested parties. They did give us definitions. Business entity is any entity recognized by law through which business is conducted, including sole proprietorships, partnerships, or corporations. Governmental entities are cities, counties, school districts, special purpose districts, or authorities. Interested parties is a person who has controlling interest in the business entity with whom a governmental entity or a state agency contract, or who actively participates in facilitating the contract or negotiating the terms of the contract. And then state agency is basically a state agency. We're not going to worry about that right now. So when is it required for a business entity to disclose interested parties? When a contract of a governmental entity or state agency that requires either an action or a vote by the governing body entity or the agency before the agency can contract, or the value is at least $1 million. So if you're a city or an ESD and your board has to basically vote to sign that contract, you're going to have to basically do this disclosure interested party form. When is disclosure of interested parties required to be submitted, or to whom it is submitted? Well, first, the business entity has to submit it to the governmental entity or the state agency at the time the business entity submits the signed contract to the entity or the agency. So it is going to be another form that is added to the contract when they send you a signed copy of the contract. And then the governmental entity or the state agency has to submit that to the Texas Ethics Commission no later than 30 days after they receive the disclosure. What is the Texas Ethics Commission involvement with the disclosure of interested parties? Well, they're the ones that created the form. They promulgated rules to implement this new law, and they basically post all the disclosure forms on the website, and I've given you the website. The Texas Ethics Commission has basically gone through already one rule change on this. They've already started kind of doing more rule changes on it. They've already told the legislature they really have to go and fix this law. So any kind of questions you give me on this, they're still kind of up in the air because it keeps fluctuating, it keeps changing.
I will say SafeD is keeping apprised of this as well, because we're having to send out, basically, when we have with your ESDs out there who are members, that's essentially, as far as we can discern, a contract, and or possibly, I should say, I shouldn't speak in definite terms.
Yeah.
I should know better than that. So you may be seeing SafeD getting involved in these disclosures and having that disclosure form sent along with your membership renewal.
Right. Yeah, at TML, we're going through the same issues, basically, for our memberships to cities, and so we think we have to send the form to them too, because they might have to fill it out for theirs.
So be on the lookout from that, from SafeD for your ESD memberships.
So that's all I have for disclosure of interested parties. We're going to move on to gifts to public servants, which is Penal Code 36.08. And this is more of a question. So the question is, can a public official or public employee accept a gift or benefit that is simply provided in appreciation for a superior public service and that is not in exchange for any official exercise of discretion? And so you've got 3. A, no, not for any reason. Yes, because they are a good public servant. And C, yes, as long as it falls under an exception. What do you think, Cliff?
My instinct says A,
right?
But I'm going to say C because I think it's a trick question.
You're right, because the answer is C. In general, they're not supposed to accept any gifts or benefits from a person who is subject to their jurisdiction. However, there are exceptions. And there's a few of them. So there's token gifts, which is basically a value of $50 or less that excludes cash or negotiable instruments. Negotiable instruments are basically gift cards. You can't give them gift cards. You can't give them cash. Gifts from family members or close friends. The public service family or personal friends, you can get gifts from your family. That's basically what that is. You can also get gifts from your business relationship. If you have an independent business relationship with someone, they're going to be allowed to give you gifts. Statutorily paid fees. So if the law says you get paid for a certain function, you're going to get your fee. Payments for expenses. A benefit given in honor of or appreciation of the public servant who is required to file a campaign finance report or a personal financial disclosure statement. And if that's so, it's used solely to defray the expenses or accrued from the performance or duties, and the benefit and the source of any benefit is in excess of $50 is reported on the statement. So if you have to fill out a campaign finance report or a personal finance disclosure statement, basically if you get payments of expenses, that's okay because it's defraying the expenses for you to do that duties. But if it exceeds $50, you better report it onto your statement. Political contributions, so you can always get your political contributions. Food, lodging, or transportation expenses. So if you go to a seminar or a conference and you do a speech, they can pay for your food, lodging, and transportation expenses. And then if you can do food, lodging, transportation, or entertainment expenses as accepted as a gift. So as long as the person who's paying for it is with you at the time that they're either paying for your food or the transportation or entertainment, then you can get that. That's an exception to the gift rule. Question number 2, what can a public official or a public employee do if the official is presented with an unsolicited benefit? A, keep it because it was unsolicited, donate it to an educational charitable organization, or C, do not keep it.
C, do not keep it.
C, that is right, but B is also right.
Well, I was figuring B and C, so I was on the fence.
You were on the right track.
Right.
So yes, B and C. So if you get an unsolicited gift, basically you can turn it down. You can donate it to a recognized tax-exempt charitable organization formed for educational, religious, or scientific purposes, or you can donate it to your governmental entity if they have the authority to accept gifts. What are the consequences for violating the gift law? You're looking at a Class A misdemeanor, fine not to exceed $40,000 and or 1 year in jail. It could also be grounds for removal or recall depending on the state law or city charter. So don't accept unsolicited gifts you don't need.
Right.
Honorariums, Penal Code 36.07. What is an honorarium? Well, basically, the Ethics Commission says it's a payment in recognition of acts or professional services for which custom or proprietary forbids a price to be set. Generally, it's when you get paid for something you already do. That's what it means. So you're prohibited from soliciting, accepting, or agreeing to accept an honorarium in consideration for services that the public servant would not have been required to provide but for that public official or employee's official position or duty. So that's what's considered honorarium. There is an exception. Again, the exception, if you're going to a conference in rendering services such as a speech, they can pay for your meals, transportation, and lodging expenses for that. Violation of the honorary law is the same as the gift law. Class A misdemeanor. You're looking at almost $4,000 and maybe 1 year in jail. Misuse of government property, Penal Code 39.02. Does state law prohibit a public official or public employee from using government property for personal purposes? Yes, the state law does. You can't misuse government property, services, personnel, or any other thing of value belonging to the government to either obtain a benefit or to harm or defraud someone else. What is misuse? Misuse is either an agreement is contrary to an agreement in which the public official or public employee holds the property. It's either a contract or an oath of office of that public official or public employee, contrary to a law that prescribes the manner in which you're supposed to the disposition of that property, or contrary to a limited purpose in which you basically received that property. Consequences of violating misuse of government property is an offense, and it really depends on the value. So if you misuse the value of the thing that was misused is less than $100, it's a Class C. As you go down, if it's between $750 and more and less than $2,500, it's a Class A. And as you go up in value, you're going to go up in basically what the crime's going to be. So a felony of the first degree is when the value of use of things misused is $300,000 or more. So the more value of the misuse, the worse the crime's going to be. Misuse of official information, Penal Code 39.06. Does state law prohibit a public official or public employee from using confidential information to gain a benefit or advantage? And the answer, of course, is yes. It does prohibit you from disclosing or using confidential information to which the official employee has access virtue of their employment or their office, and that the public does not have access to. So to acquire, aid another person, acquiring pecuniary interest in any property, transaction, or enterprise, to speculate or aid another speculation, or to gain a benefit or with the intent to harm or defraud another. What is information that has not been made public? Basically, any information that the public does not generally have access to, and generally is prohibited by the Public Information Act. What is the consequences of the misuse of official information? It is a third-degree felony. So you're looking at 2 years to 10 years in TDCJ and or a fine up to $10,000. No one wants to do this. And grounds of either being removed or recalled. So this is a big no-no. Do not misuse official information. Nepotism, Government Code, Chapter 573. What is nepotism? It basically prohibits a public official from appointing, confirming the appointment, or voting on the appointment of a close relative of certain public officials to a paid public position or employment. Which public official does nepotism apply to? Well, it is the public official that basically has the hiring and what we call the hiring and firing authority, or the final hiring authority, or a member of the governmental body with that. That is, the final hiring authority is the individual or entity that has control over basically the hiring decisions for your governmental entity. So for cities, sometimes it depends. Like if a city has like a city manager, and the city manager has the final hiring authority, then usually that's the person you have to watch out for the relationships for. Who is considered a close relative? Close relative is a relative that's either in the first, second, or third degree of consanguinity, or the first and second degree of affinity. So all that time we were talking about degrees, we're about to figure out what the hell that means. What is consanguinity? Well, consanguinity means that you're related to the public official by blood. These are examples: brothers, sisters, mothers, fathers. What are the degrees? Well, first degree is mother, father, son, or daughter. Second degree is your brother, your sister, your grandparents, your grandchildren. Third degree is your aunt, uncle, niece, or nephews. Adopted children and half brothers, sisters are considered to be full-blooded under consanguinity. Stepbrothers, sisters are not. So when we talked about all that before in conflict of interest, this is what we were talking about. This is what the degrees are when it comes to blood. Affinity is when you're related by marriage, and that's wife, husband, mother-in-law, father-in-law. And so the first and second degree is, the first degree is your wife, your husband, your stepchildren comes into this play. Son-in-laws or daughter-in-laws. Second degree is your brother-in-law, your sister-in-law, your spouse's grandparents, your spouse's grandchildren. What does the public official do if he or she has a nepotism conflict? The public official nor any members of that governmental body can hire that close relative unless a specific statutory exception applies. So not only is the public official unable to hire their close relative, none of the members of that governmental body can do it either. Does nepotism prohibit a person from running for a public office if the person has a close relative who is currently a public employee?
I'm going to go with yes.
You would be wrong. It's no. No, you can always run, but if the person gets elected, then the close relative might have to resign unless they're protected by the prior continuance employment exception. And that exception basically is that the employee may continue to be employed if they have a sufficient time period immediately prior to the appointment of the election of the close relative. So it's 30 days that the public official is appointed. It's 6 months that the public official is elected in an election other than a general county or state election. It's 1 year if they're elected in a general county and state election. So we got a whole scenario, so start thinking, Clay.
Okay.
So Sheriff Walter was elected to office in January 2001 and re-elected in 2005, 2009, and 2013. Prior to his election in 2001, Rhonda, a dispatcher, became employed by the Sheriff's Office in October of 1999. As time progressed, Sheriff Walter and dispatcher Rhonda became more acquainted and eventually fell in love, and they got married in February of 2010. The local watchdog has written an editorial in the local newspaper accusing the sheriff of violating nepotism laws because he was still employing his now wife, Rhonda, at the sheriff's office. So question number one, is the Sheriff Walter violating the nepotism law by continuing to employ his wife Rhonda as a dispatcher in the sheriff's office? A, yes, because now they are related by the first degree of affinity. Yes, because now they are related by first degree of consanguinity. No, because even though they are related now, Rhonda was employed by the sheriff's office prior to marrying Sheriff Walter over a year before the sheriff was elected, and she has remained employed since his elections. No, because nepotism does not apply if the marriage happened after the sheriff was elected.
C.
Very good. C is correct.
Legitimately.
Yes. She had the continuing employment exception because they got married way after she got employed. So yes, so it is C. She could still be employed. Question 2. Can Sheriff Walter promote dispatcher Rhonda to head dispatcher while they are married? Yes, because she's the best dispatcher and she deserves it. Yes, because she is his wife. No, because she is his wife.
I'm going to say my thinking here is that the nepotism, I don't know if it applies to promotion. I know it applies to hiring. I'm going to say I'm feeling C, but I'm going to go with A.
You should have stuck with C. Answer C. So although she was able to keep her job, that doesn't mean that she's going to be able to be promoted because Sheriff Walter may not participate in deliberations or voting on the change of status of Rhonda if the action applies only to her. So if they were going to give all the dispatchers a raise, then she could get a raise. But just because to promote her, it's not going to be able to happen. Consequences of violating nepotism law. A public official commits to official misconduct. Fine not less than $100, not more than $1,000. Public official can be removed from office if convicted, and the conviction is final, and any employment contract is voided. So that's what happens when nepotism law is violated. Dual office holding and incompatibility. Dual office holding is a constitutional provision. It's Texas Constitution Article 16, Section 40. Basically, no person shall hold or exercise at the same time more than one civil office of emolument. What does civil office of emolument mean? It's a paid public office. The distinction between public office and public employment. A public office is determined by the officer holder's authority to exercise governmental power for the benefit of the public, and the officer holder's independence from the control of other governmental bodies or officials. So a public officer is basically like the mayor. They're going to have the independence. It's going to be the head of the ESD. It's not going to be the city secretary, because usually the city secretary is an employee. They do have a governmental body like the city council has control over her actions. Definition of emolument: it's pay or some other benefit, compensation, or things of value received in exchange for the person's service as an officer. So the example of a city that might be a city council that they might not get paid, but maybe they get insurance through it, that would be considered emolument still. Incompatibility is the next thing. So not all the time dual office holding is going to apply. Maybe incompatibility will. It's a prohibition against a person holding certain public offices at the same time because of practical conflict of interest that might arise. And there are three types: self-appointment, self-employment, and conflicting loyalties. Self-appointment basically prevents a governmental body from appointing one of its own members to a public office. Self-employment basically means a governmental body cannot also be an employee of their entity. And then conflicting loyalties prevents a person from holding two public offices when the interests of the two entities may conflict, and when voting on behalf of the one public entity might possibly compromise the interests of the other public entity. So basically what we look for when we're dealing with conflicting loyalties is if they're both public offices, if they have a boundary overlapping, if they're both taxable entities, and if that happens, then they could be having a conflicting loyalties issue. So we got a scenario on this one. It's the best way to learn it. The city of Texasville has a 5-member city council. Each council member serves 2-year terms. Council members do receive $50 for every meeting that they attend. The county of Tejas has a commissioner's court that has 4 members and a county judge. Commissioners get paid salaries once they are elected, and they serve 4-year terms. Councilmember Davis has decided to run for county commissioner in the county of Tejas, where Texasville is the county seat. Councilmember Davis was just reelected to the Texasville City Council and still has over a year left on her term. At the press conference announcing her candidacy for county commissioner, one of the reporters asked her if she planned to stay a council member before the election. She stated that she did plan to continue to be a council member. Same reporter asked her if she planned to stay on the council as a council member if she becomes the next county commissioner. Councilmember Davis stated that she would do both positions because she thinks it would be the best for both Texasville and Tejas County, because it would help bridge the communication gap that sometimes happen between governmental bodies. Question number 1, would dual office holding prevent Councilmember Davis from being a city council member and a county commissioner at the same time? Yes, because both positions are paid. Yes, because both positions are public offices. Yes, because both positions are public offices and paid. No, because county commissioners are exempted from the dual office holding.
C?
D.
D.
The Constitution actually does have some exceptions in it, and county commissioners is an exception.
Wow.
And so that dual office holding would not prevent it.
That's good to know, because I did not know that.
I know.
I've made presentations to county commissioners and judges that I wish I had known that. So they are exempt from dual office holding.
Yes.
Okay, well there you go.
Exempt them.
That's good to know.
Would incompatibility prevent Councilmember Davis for being a city council member and a county commissioner at the same time? Yes, because it would be considered self-appointment. Yes, because self-employment. Yes, because conflicting loyalties. No, because dual office holding allowed it.
I'm going to say C on this one because I think the county and city could be at odds.
That is correct.
Oh,
Yes,
okay.
so it would be C. Conflicting loyalties would apply basically because Texasville and Tejas County have overlapping boundaries. Texasville is in the county. Both entities are taxing authorities. We all know we get property taxes from our counties. A city could do property tax or sales tax or anything to that effect. And Councilmember Davis would be holding two public offices where the interest of one might conflict with the interest of the other. So she would not be able to hold both. Bonus question. Does the Councilmember Davis automatically resign her position on the Texasville City Council when she accepts the position of County Commissioner? Yes or no?
And that's she was city council.
She was
first,
city
right?
council first. She was 2 years terms.
I know that's the case in dual office holding, but since we're using incompatibility, I'm going to say A.
Correct.
Okay.
Yes. Automatic resignation operates as a matter of law only when either the public officer accepted a second public office that is paid position, or the person accepts a second public office that would present a conflicting loyalty problem under common law incompatibility. So yes. Sometimes it applies when the public official announces candidacy for the second public office. In her case, it didn't because her terms was only 2 years. Now, if her terms were more than 2 years, 3 or 4 years, she would have automatically resigned when she announced for candidacy if she had more than a year left on her term. Consequences for violating dual office holding or incompatibility. There's no criminal penalties for that. But such a violation would have to be challenged through civil actions in a district court. So let's say Councilmember Davis said, screw it, I'm not going to give up either one. How would you get her out? Basically, you would have to go to district court to either remove her or have the court determine she couldn't do both. Last but not least is bribery. Penal Code 36.02. What is bribery? Well, basically, it is illegal for a person to offer, confer, or agree to confer, or a public official or employee to accept, agree to accept, or solicit any benefit as consideration for a decision, opinion, or recommendation that public servant exercises discretion for, or for a violation of duty imposed in the law on a public servant or party official. So basically, you can't accept money to make a decision. What is considered a benefit? Anything reasonably regarded as pecuniary gain or pecuniary advantage, including benefit to any other person in whose welfare the beneficiary has a direct or substantial interest. So they're basically talking about your family members or maybe a business partner, depending on what the benefit is. In other words, benefits would include anything that is offered that a reasonable person would consider having some monetary value, whether it's given to the public official or someone who the official has a direct or substantial interest to, as I said, family member or business associate. Bribery question number 1. Does the state law prohibit a public official or employee from accepting a benefit if the item is offered or accepted after the exercise of official discretion? Yes for public officials, but no for public employees. Yes for public employees, but no for public officials. Yes for public officials and public employees. No for public officials and public employees.
If the item is offered or accepted after the exercise of... D.
C.
Oh.
Yes. So it doesn't matter if it's before or after. They cannot accept it. So
I get confused. Yeah, I got my head around wrong. Okay, yes, C. I knew it.
Yeah, so even if they've already exercised it, yeah, it could still be considered a bribery. It's not a defense if the benefit was offered or accepted after the public official ceased to be a public official. So even if you got off the council and they still paid you for it for something you did, it could still be considered bribery. Also not a defense if the influenced person was not qualified to act in the desired way, whether because he had not yet assumed office or he lacked jurisdiction or any other reason. So even if that person really didn't even have the authority, they can't accept the bribery. Is a plaque considered a benefit under the bribery laws? Yes, if it costs more than $50. Yes, no matter what it costs. No, but do not make it too elaborate.
C.
Correct. C. The Ethics Commission put out a advisory opinion and basically said plaques, unless quite elaborate, and I think they mean like 24 karat gold and diamonds on it, would not be considered a benefit under the bribery law of such item is unsolicited and not offered or accepted in exchange for any action or inaction on the past of the public servant. Exceptions to bribery. If the benefit is a political contribution or expenditure made or reported in accordance with Chapter 305, basically the lobby rules, that's an exception to bribery.
And we don't have to make any comments on that.
Consequences for violating the bribery law. Person prosecuted for bribery is guilty of a second-degree felony, not less than 2 years, but not more than 20 years in TDCJ, and or a fine not to exceed $10,000. Also grounds for removal or recall. So that's the presentation.
Oh.
We got through it, so I'm sure there's a lot of questions.
We have quite a few. Okay. I want to really quickly remind everyone, thank you so much, Zindia, for that presentation. Yeah. I want to remind you how to reach us here. We're going to try to get to your questions in the last 5 or 10 minutes or so that we have here. To contact us here, you can call us at 512-251-8101. Email us, safed@Texas, and that's Texas is spelled out, .net. Text me here in the studio, 512-567-0857. No text messaging rates may apply, and don't call that number because I'm going to be asking questions. And you can fax us here at 512-251-8152. So let's get right to it. We had this question. This one was actually filed beforehand, and we have a similar question through email. Can a person who has been appointed to an ESD board and is still a member of the volunteer fire department hold an office on the ESD board?
That generally would be a conflict of interest question, generally under 171. Probably they can, because part of the conflict of interest is either you have to have a substantial interest in a business entity, and one of those is your income has to be at least 10% or more of your gross salary for the previous year. Because volunteer fire department or volunteers are volunteers, so they usually don't get any money. They probably can be on the ESD board. Now, public opinion on that or public perception, that's another thing.
Well, let me give you a more detailed scenario from our email. We have an ESD officer that is also the assistant chief of the VFD that we are contracted with. Okay. Is it a violation of the conflict of interest rule based only on that fact? He does not own any property or own interest in anything that has to do with the VFD. He does not receive any income in any way from that VFD. We were told that an ESD officer cannot be a voting member of the VFD we are contracted with.
I think the same thing would apply because he doesn't get paid. He's not gonna. The conflict of interest law is not going to apply. But again, the public perception is a huge issue, and so public perception might require that he doesn't vote on that stuff or doesn't discuss it because it pertains to his particular volunteer fire department.
We get this question a lot, and we should really kind of address it from and Zindia can address it from the legal perspective and what the statute says. But there's also probably some common law conflict of interest rules, and there's a best practices aspect to this as well. Because if you have and as this email question says, he's the assistant chief, he's not maybe on the board of the VFD. But if you're contracting with the VFD and you have to negotiate, there's a danger of self-dealing there. If he were to be on the board of the VFD and the ESD board at the same time. If he's just the assistant chief, you can say, well, that's not the problem. But there's also a perception problem, like you said. And we also have an issue where he does receive benefit down the line. It's in his best interest for the VFD. There is some loyalty issues there. Now, when we talk conflicting loyalties, we're talking mostly about incompatibility, and VFD is not a public office, so there's not that issue there in terms of the statutory or the conflicting loyalties that we talked about tonight. But there is an issue with loyalty, and you just have to be very, very careful ultimately.
Yeah, I agree.
Because public perception, as well as the idea that you're serving two masters there, if you have someone who's deeply invested in the VFD and you're contracting with them, and they're on the ESD board, and the ESD is doing a contract with the VFD, you have two loyalties there.
Right.
It's probably best to recuse from those negotiations and from that vote.
Yeah, I would basically suggest that, because who knows who your watchdog is. There could be the one that brings it to light, and then everybody gets upset that you're negotiating something that, yes, you get a benefit from, even though substantial interest, at least the way that conflict of interest is written in 171, doesn't seem to require that you recuse yourself, but maybe you should recuse yourself.
Right, and we see this all the time, and it's not because somebody's trying to do something necessarily wrong.
Right.
In a lot of these communities, especially rural communities, it's hard to find folks
Yeah.
who are willing to serve on your ESD board who don't have some sort of interest in the fire service, and so it's easy and sometimes great to have someone with knowledge of the fire
Right.
service, your assistant volunteer chief, who's willing to also do the duty of ESD board commissioner. So it's understandable,
Right.
but you just are walking a fine line
Yeah,
there.
it's a very
And you're
fine
you're running some risks, and it's best for everybody to keep on up and up. If you're going to go down that road, you're going to want to recuse from anything that has to do with the VFD contract and that kind of vote, because you can really run afoul, and the last thing anybody wants is a lawsuit by some taxpayer watchdog group. So
Exactly.
saying, you're serving two masters,
Right.
basically.
Exactly.
So let's see here. Moving on, and that's a fact-specific scenario.
Yes.
So let's see here. Can a husband sit on a water board and his wife be an ESD commissioner? Husband is on the fire department board. Wife is on ESD board. Okay or not? So the wife is the ESD commissioner. The husband's on the water board.
Yeah.
That should be all right.
Yeah, that's okay. I mean,
If
they
there-
could actually, if there was an election, they could be elected to the same board. There's nothing in the nepotism law that prevents them from being elected to a position. Only the issue with nepotism is if they're an elected position or an appointed position, and they try to give a public paid position, to a relative.
So you've got two separate scenarios here with the same people. The water board and ESD commissioner, but he's also on the VFD board, the fire department board,
Right.
and she's an ESD commissioner. Nothing probably wrong on the face of it. You can be those things.
Right.
But if you're doing contracts, if the ESD is doing a contract with the water board, or the ESD obviously doing a contract with the VFD.
They're going to have to look to see about how that's going to affect them when it comes to making that decision. I mean, they might have a conflict of interest. I doubt it, because they probably don't get paid to do that job. But again, we're down to public perception. How is the perception is if the water board has to do a contract, the ESD board, you have husband on one, wife on the other. What does that look like? How are they going to make that kind of decision? Again, that might be a public perception issue as opposed to a legal issue.
Right. Couple of misuse of public property.
Okay.
Can we have fire trucks in a parade, or is that a misuse? And then another one, does using a fire tanker to fill a citizen's private swimming pool a violation of using official equipment?
The second one is.
Yeah.
The second one definitely is. That's a misuse of governmental property. You're not supposed to use it to fill up your neighbor's pool or even your pool. That's a misuse. The fire truck in the parade, no. That's, everyone does that. That's not considered a misuse.
Okay. A couple more questions here, but get your questions in. We have time for a few more if you have some. Text me 512-567-0857. Email us safed@texas.net. You can also call your questions in to 512-251-8101, or you can fax your questions to 512-251-8152. Would an ESD be self-appointments? Would an ESD be a self-appointment by a county commissioner? So you said county commissioners are
Exempt from dual
office holding. Can the county commissioners appoint the ESD board? Can they appoint a county commissioner?
Can the county commissioners appoint a county commissioner to the ESD board? No.
Even if he doesn't vote on it at the county commissioner's court?
No. They can't appoint him because once the county commissioner is on the ESD board, he runs into a conflicting loyalties issue.
Right.
So they can't be on both boards anyway. And so they wouldn't be able to appoint a commissioner to the ESD board to begin with.
Okay. So I wasn't completely wrong. I was just, when I would go out and say county commissioners can't serve on the ESD board, it's not dual office holding that gets it.
Yeah, it's incompatibility, conflicting loyalties,
great.
Yes.
Can we accept gifts, honorariums, reimbursements in excess of our statutory stipend? So there's a statutory stipend in 775. Producer, can you remind? Is it 3,000? Okay. Can they accept? Is that affected?
I've never read the statutory stipend, so this is kind of off the cuff. It would seem that they could get their full reimbursement for the travel and everything. I would think the stipend is, I'm assuming the stipend is...
It's like their per diem.
Their per diem.
For going to meetings and doing official
business. So I would have to say the statute would basically you'd have to follow the statutes for the per diem part of it. So I would have to say, you probably can't get over because they've put in statute how much you can have, and so that causes an issue.
Okay. Let's see. Okay, another nepotism question here. If my son-in-law is the fire chief, can we still hire him if I'm not the final hiring authority? Assuming, I guess, this questioner is on the ESD board. Can he hire his son-in-law? Can the ESD board hire the son-in-law as fire chief? I guess this is in a situation where the ESD is contracting, or not contracting. The ESD is actually
the service provider. Well, I guess my question is, who has the final hiring authority? If they don't, then generally probably they could, but I don't know who has the final hiring authority.
Well, the board would have the hiring authority. I think he's just saying he wouldn't take part in the vote.
No. Okay. Now they still wouldn't be able to hire the son-in-law.
Because the board has...
Because the board has the final hiring authority.
The ESD board, if you're hiring the chief, nepotism still applies.
Yes.
Now, what if, since I don't have all the facts, what if the son-in-law, he said, is the fire chief? What if he's the fire chief of the VFD and they're contracting as independent entities?
That's not the same thing.
Okay.
Yeah.
Would you still have to recuse yourself because you're dealing? That's kind of back to the husband and wife.
That's kind of back to the first degree of affinity, or the son-in-law, if I remember correctly, is not first degree. I think it's second degree.
Okay.
So, and we can go back and look eventually, but so I think that she could still legally work on the contract. It wouldn't be a conflict of interest for her. Again, public perception is a whole nother thing.
Right. Yeah. So a lot of good issues. We're actually out of time here, so we're going to have to go straight to your getting credit. Yeah. But thank you again, Zindia, for being here and that wonderful presentation.
Oh, no problem.
To apply for your 1 hour of credit from tonight's webcast, I need you to go to www.safehd.org/1667e5.pdf. And to open that PDF, use the password scoundrel. Really? Scoundrel. SCOUNDREL. That's one word, all lowercase. It's below my face there. Should be www.safe-d.org/last Monday 1667e5.pdf. And the password there is scoundrel. SCOUNDREL. That's one word, all lowercase. You should get your PDF that you can send back into us for your hour of credit. I do want to mention that this hour, for those of you who are trying to get your Certified Emergency Services Commissioner, this hour will count for your ethics requirement. on that, so you can count that on your application. We're busy trying to certify our third class. Those are still ongoing. We're going to mention our second class that we announced at the last conference in Galveston. We're going to announce them in the next newsletter, and then we're going to try to get our third class certified because there's been so much interest in this. So get those in. A note on our scheduling. We're actually going to be at the State Firemen's and Fire Marshals Conference at the end of June. So that's where we'll be the last Monday of June, so we won't have a webcast then. We're going to try to make it up later, so keep posted on that. But that's our webcast for tonight for the first Monday in June. Thanks again to Zindia Thomas for being with us as always.
You're welcome.
For everything you do for us. Keep checking the safety newsletters, both print and electronic, and our website for information about future webcasts and training opportunities. From the safety headquarters here in Pflugerville, I'm Clay Avery. Good night.
Good night.